Good morning, everybody. Say good morning. Good afternoon, everybody. Attorney Greg Lake here. Welcome to the Entheogenic Esquire podcast and channel. Here for yet another live again today, and pretty excited for this one, just in the sense that I feel like I've been able to do some meaningful research in helping to frame this issue that we're currently experiencing, right, with the DOJ, Pam Bondi, Kash Patel, and the Epstein files, right? So it's no secret here that people feel that there seems to be some type of large cover up, okay, trying to hide or conceal or obfuscate potential co-conspirators, other perpetrators of underage minor victims by the Department of Justice. And so starting yesterday, really before, but really after the live stream, I really started digging into the actual Epstein files. And to be honest, I just went to the Department of Justice. I went and got an index of the different data sets, what each of them are, and really just started picking. I went to the document section, the ones that I knew were certain documents from, I believe, the FBI files. So, and that'll play into what we're going to be talking about today for sure with regards to Kash Patel. But and how you doing, Miss Susan? Very glad you're here. Thank you all. Just thank you for all my supporters. If you haven't already, please subscribe, like, comment, all that good stuff. It really helps the algorithm. How you doing, Elena? As many people know, I'm starting this new channel. I'm doing the content that obviously the algorithm doesn't like to push out. And so, in that spirit, in that way, any help that I can get as far as just sharing and getting the good word out, subscribing, very, very helpful. But I am completely dedicated to bringing you as much truth as I can find. And so back to where I was looking through the Epstein files yesterday and just happened upon a lawsuit from 2019. This lawsuit was filed in the Southern District of Florida, so federal court. And it was filed by two of Epstein's, I guess we could say, original victims, right? So these were the victims that were part of the 30 plus victims comprising the state suit, right? So I think most people are aware that back in 2007, Jeffrey Epstein was given an absolute sweetheart deal by both the federal government, which we're going to talk about, and the state, Florida State, there for pretty solid charges related to, I mean, we can all guess what it was, CSA. With a lot of victims. And so, again, many people are aware of that. And so I just happened upon this. And what it was is it's an opinion in order from the federal court ruling in favor of these two victims from that original batch from the 2007 court proceedings, basically suing the government, the Department of Justice, for violating their rights under the Crime Victims Rights Act. Yeah. CRVA. Okay, so it's a federal statute and it guarantees that at the federal level, at least, and we're going to talk about what the law's requirements are and things like that here in just a minute. But essentially, in a nutshell, it gives victims the right to more or less be involved in the maybe not so much the investigation per se, other than providing information and helping, but really in the charging decisions and the how the case proceeds, and especially when, as we'll see in this instance, when there's plea bargains, non-prosecution agreements, as we're going to talk about today, like especially in those instances, right? This law really wants to make sure that the Department of Justice is, brings the victims into this equation and makes them at least somewhat of an integral part of how this all proceeds. And so what we're going to see today is that the Department of Justice and all this stuff, like all the facts we're going to be talking about, when we talk about email exchanges, these things between the Department of Justice, Epstein's lawyers, all these are facts. Okay. These are facts that have been found by a federal judge in an opinion in order. Okay. So basically the judge will take all the affidavits, depositions, discovery responses, all the evidence, and then figure out what makes sense to them, what they feel is admissible and good evidence, and then they will do their opinion in order. And in those documents, normally they'll have, like they do here, maybe 15, 20 pages of just a narrative, right, from all the different factual documents and evidence, picking what they find credible and making a narrative out of it, right? And then they go into their analysis under the law, et cetera, et cetera. And so as I'm reading this 2019 opinion in order from this judge in the Southern District of Florida, talking about essentially how the Department of Justice, in my opinion, completely cut out these victims from being involved in any kind of negotiation or input into their non-prosecution agreement they reached with Jeffrey Epstein. It's completely disgusting to me. It really is. It's completely disgusting. And the reason why I bring it up today, right, is because as my thumbnail indicated, it's symptomatic of what we're seeing today. I completely believe that. I don't think that this is, even though I'm not trying to defend or prop up Pam Bondi or Kash Patel by any stretch of the imagination, but this is their lineage. Yeah, that's right. We're going to learn about their lineage today, the lineage that they inherited when they stepped into that office. Were they aware of it? Maybe they weren't. I can't say for sure, but what they stepped into was a whole lineage of protecting Jeffrey Epstein, his co-conspirators, and all the other billionaire elites that were part of this trafficking circle that he had. And so these things that we're seeing today with Pam Bondi and the Department of Justice, this is nothing new. This is absolutely nothing new. And considering that Pam Bondi was the attorney general in Florida and was an active member of their bar, and I believe a state prosecutor at the time that all this was going down, I mean, I'm pretty sure she had a pretty good idea of what was going on in this. Okay. And when people say that the feds gave Jeffrey Epstein a quote unquote sweetheart deal, they gave him a non-prosecution agreement, right? And we're going to dig into that later. That also extends to his co-conspirators in a lot of ways, right? So we're going to dig right into it because, again, I think to be able to truly and fully understand what we're seeing today, we're going to need to go back and see how the DOJ has treated and worked with these victims in the past, and also see how far they've gone to appease Jeffrey Epstein to make sure that he's protected. And moreover, as we're going to see as well, their attempts at obfuscating, at keeping all this not only away from the victims, but away from the public as well. Okay, so the fact that people weren't really well informed about Jeffrey Epstein from early on, starting back in 2007, is by design. Okay, this wasn't a fluke. This wasn't even necessarily because the media didn't want to cover it. It's because the attorneys and the DOJ intentionally took a specific course to ensure that this information was not widely disseminated and publicized. And what do we know? We know from 2007 to whenever Jeffrey Epstein was unalived, or wherever he is, right? Whenever he went off the map, off the reservation, right? How many victims were there, right? So what we're looking at is, and we'll see this as it plays out today as we discuss it, basically because the DOJ refused to honor its obligations under federal law to notify the victims and actively sought to suppress this information in the public record. I think it's fair to say that there are an untold number of victims that, Thomas Massey, Ro Khanna, they're probably dealing with a lot of the victims that came as a consequence of the DOJ's intentional obfuscation of what was going on here, and the intentional move to enter into some non-prosecution agreement and ensure, as we're going to see, they also worked to try to ensure that the state did not mandate that Jeffrey Epstein go to prison. Okay. Yeah, it's a lot. It really is a lot. But so again, we're going to go through today this opinion in order, and actually we're not going to go through all of it today, because to do everything from this document that's worthy of being brought to your attention in one live stream would be much. It would be much. So we're going to do some today. I'll bring some more tomorrow. We might even have a third episode on really just digging through this initial instance. And I'm very grateful because the judge here, instead of having to go back through all the original documents from that case, as far as what we're talking about today, the DOJ's actions in covering this up and helping Jeffrey Epstein, he just laid it all out. And the great thing about it, ladies and gentlemen, is that instead of us having to sift through a lot of the BS, the judge did all that. Judge and his clerks did all that and brought it to us kind of in a really nice, neat fashion, as you're going to see. And I think it's going to make a lot of sense to you, and I'm going to explain it to you along the way. And so today, the portion of this opinion in order that we're going to be looking at really goes towards the DOJ trying to appease Jeffrey Epstein. Basically, the DOJ bending over backward, and you'll be the judge, ladies and gentlemen. You'll be the judge today, whether you believe that the DOJ put in extra double team effort to try to appease Jeffrey Epstein and make sure that he did not suffer the consequences that we all definitely believe that he should have experienced. Okay. All right. So let's see. Just want to make sure. And part of this, right, is, and I've said this several times, is that, we're all aware that the recent fight, and this is really what put me on this certain aspect of it, the DOJ's treatment and attitude towards these victims, was when this latest file release came out. They, and this was according to the BBC, just so y'all know, it's where I got the article, but they say almost nearly 100 victims' names were not redacted, right? And as we spoke in a few live streams ago, the Epstein Files Transparency Act explicitly required that these victims' names. It's like, and let me say this: when I look at the act, the law, if I were a prosecutor tasked with complying with it, if I were to tell my staff going through these documents, if there's one thing, if when you're redacting these documents, if there's one thing that you stick to above all else, priority, it's keeping the victims' names out of there, right? Keeping the victims' names. Now, as we look at what they did, what happened? Well, they released almost 100 victims' names. They excised or redacted a lot of potential co-conspirator perpetrators' names. So they pretty much did the opposite of what the act called for. And to be quite honest, ladies and gentlemen, they did the opposite of what a good and moral, decent person would do, in my opinion. In my opinion. I mean, be it as you will, at the end of the day, if you have a person who's obviously a woman, now most of these are women, I assume, who, in their youth were perpetrated by Jeffrey Epstein, I don't understand why it takes a law to tell you that not only that you need to release these things and go investigate and potentially prosecute, but I don't know why a law should have to tell you that you should have to, protect these victims' names. And not only that, and as I've said before, normal court procedure dictates that things like that would be excised or redacted from these documents. Okay. So again, it extends a little bit beyond just requirements in the Epstein Files Transparency Act. It really is kind of a common court procedure to have these types of redactions. Okay. So anyways, let's see. And we're going to talk about too, because as I said just a minute ago, the judge in this case made findings related to whether Jeffrey Epstein was involved with just himself or co-conspirators, right? And obviously the judge, as we'll read in just a minute, concluded that absolutely that there were co-conspirators involved. And so we're going to speak kind of in depth about what that means in terms of Kash Patel's and Pam Bondi's testimony, or at least Kash Patel for sure. I don't know if I have specific recollection of Pam Bondi saying that, oh, it was just Jeffrey Epstein, but we do know Kash Patel did, right? And so we're going to talk about what that means in terms of a federal court made this finding in an opinion and order in the public record, and then what that might mean in terms of Kash Patel's potential culpability in making the statements that he did to Congress under oath. Okay. So the lawsuit 2019 was brought against, and it was only two of the victims. So, and obviously it doesn't name them here, nor would I name them here if I knew it. But two of them in particular filed suit against the DOJ for not informing them of the process and the actual non-prosecution agreement that they reached was with Jeffrey Epstein until it was too late, until they can do anything about it. Okay. So, and that's going to be mostly tomorrow. We're going to talk about most of the obfuscation from the victims and the public. But today we're really going to be going through the part where Judge talks about the DOJ basically doing everything that they can. You'll see what I'm talking about. I mean, bending over backwards, relatively speaking, with how they treat other lawyers and defendants to try to accommodate Jeffrey Epstein to the maximum point. And so far, as we'll see at times, I do think that they violated ethical duties by all means, and might have even broken the law. I mean, those are no accusations. I can't say that for sure. I'll let you make up your mind in that regard, but I'll just let you know before we hop into it where my mind was on some of these things. And so here we go. Let's see. They negotiated and signed a non-prosecution agreement. So this non-prosecution agreement the government agreed not to prosecute Jeffrey Epstein based upon certain terms. He was convicted, had a plea bargain in the state court, which I think he might have done some small amount of like county jail time, but otherwise was mostly just probation and things like that. Really, really just a slap on the wrist. Okay. And obviously that was part of the non-prosecution agreement too. I believe him complying with that. So, in all fairness, um, the government violated their rights. Okay. So I'll say this before we get started. The court did find that, in fact, the DOJ violated the federal rights of these crime victims through the way they conducted themselves and the lack of notice and consultation that they gave to these victims throughout the whole process. So let's see. So before we get started, let's talk real quick about the Crime Victims' Rights Act under federal law, because it enumerates very specific rights that are given to victims of crime at the federal level and really dictates how that relationship between the prosecutor and the crime victims should go, in the sense of how much involvement do these crime victims need to have, must have, in the decisions of the prosecution when deciding how to handle these types of matters. So here are the rights. I think there's 10 specific rights enumerated by the Crime Victims uh, the Crime Victim Rights Act. Okay. So one, the right to be reasonably protected from the accused. Okay. And so here, obviously, Jeffrey Epstein, like I said, did not end up doing a whole lot of time, and I think minimal, if any, and was mostly free in the free world during this. Right. And so again, there's just these little elements that were like, is that really protecting them? Lewis file release, right? With disclosing these victim names. Obviously, there were co-conspirators involved, very powerful people. By disclosing these things, is that really doing the best you can to protect these people? Just putting that out there. Two, the right to reasonable, accurate, and timely notice of any public court proceedings or any parole proceeding involving the crime or any release or escape of the accused. Three, the right not to be excluded from any such public court proceeding unless the court, after receiving clear and convincing evidence, determines that testimony by the victim would be materially altered if the victim had heard other testimony at that proceeding. Four, the right to be reasonably heard at any public proceeding in the district court involving release, plea, sentencing, or any parole proceeding. Number five, the reasonable right to confer with the attorney for the government in the case. That's probably the main one here. But anyways, we'll keep going. The right to full and timely restitution as provided by law. The right to proceedings free from unreasonable delay. The right to be treated with fairness and with respect for the victim's dignity and privacy. The right to be informed in a timely manner of any plea bargain or deferred prosecution agreement. And last but not least, number 10, the right to be informed of the rights under this section and the services described in 503C of the Victims' Right and Restitution Act of 1990. So before we get started too, here are some rulings. So the court, before it jumped into its actual legal analysis, and I'm going to read this here though. So the court made some kind of specific findings in regards to the law, which I want to read here because it'll kind of help you also understand as I'm going through the facts where these violations kind of lie. Okay. So it goes. This court previously held the following with respect to the CVRA, the Act. First, the rights under the Act attach before the government brings formal charges against a defendant. So in this case, the federal government never formally charged Epstein, as we'll see. Now, they did draft an indictment, and we'll talk about that. Trust me, we're going to talk about that in a minute. So they did draft an indictment, but they never formally charged him in federal court. And so what the court is saying here is that regardless, their rights attached before that even occurred. Because it didn't, right? So second, the act authorizes the rescission or reopening of a prosecutorial agreement, including a non-prosecution agreement reached in violation of a prosecutor's conferral obligations under the statute. And we'll sort this out later too, because obviously that is material as well. Third, this subsection of the act authorizes the setting aside of pre-charged prosecutorial agreements despite the fact that the particular statutory enforcement provision expressly refers to the reopening of a plea or sentence. Okay. Fourth, the reasonable right to confer in the case, meaning the right for the victim to confer with the government in the case, extends to the pre-charge state of criminal investigations and proceedings, right? So again, the federal government was investigating. They were working with the state, as we'll see in a minute. The state invited the federal government to come in because they had evidence to indicate that his operations were so vast outside the state of Florida that it made it also a federal offense. And so they brought them in. And then fifth, the federal sex offense crimes involving minors allegedly committed by Epstein renders these petitioners crime victims under the act. Okay, so the judge established that these people fit under this act and therefore their rights, as elucidated therein, attached. And the government was under an obligation at the time to uphold and to respect these rights. And number 6, questions pertaining to the equitable defense are properly left for resolution after development of a full evidentiary record. So that might not be as pertinent to what we're talking about today, but just wanted to put all that out there. Finally, the court says, here it is undisputed that the government entered into a non-prosecution agreement with Epstein without conferring with petitioners, the 2 victims, during its negotiation and signing. Instead, the government sent letters to the victims requesting their patience. You can't make it up. Requesting their patience with the investigation even after the government entered into the non-prosecution agreement. So essentially what the government did was, as required by law, sent these victims letters, okay, asking them to be patient. They're still investigating this. And the whole time, they had already reached a non-prosecution agreement. Basically, their investigation was more or less, so that it was a lie. That was not true. They had already reached a non-prosecution agreement. We can assume at that time there was no investigation. And so the FBI actually is the one that sent the letters, completely lied to these people. But as we'll see, the reason why they lied to them was a product of a negotiation between the DOJ and Epstein's lawyers. They negotiated, let me say this again. The DOJ and Epstein's attorneys negotiated an agreement whereby the federal government would lie to Epstein's victims for the purpose of preventing them from essentially stopping this sweetheart deal from going through. Okay, so just listen. All right, so now we're going to get into this, and this is going to be the meat and potatoes here. This is where we're going to talk about specific instances of the Department of Justice appeasing Epstein, doing, as we'll see, going through great lengths to accommodate Epstein to make sure that he receives the best deal between the both state and federal law enforcement as possible. Okay, and I think it's good that y'all are here going through this with me because I am an attorney. Now, I don't do as much criminal practice, but obviously I've litigated quite a few criminal cases. I understand the process of plea bargains, things of that nature. And so I have a pretty good idea of kind of the push and pull that's normally between a prosecutor and defense attorney, right? And a lot of that push and pull, believe it or not, depends on the evidence, the good admissible evidence that the prosecution has, okay? And so I'll posit to you before we get started here, but I think you'll agree once we start reading what Judge had to say, the government had a extravagant case, a spectacular case against Jeffrey Epstein. As we'll see, they had so many victims, people that would come to court, point a finger at Jeffrey Epstein and testify that he is the one that violated them as a minor. Okay. Now, and I'm sure that most of y'all are aware of computers are really quick to hot to trot on these things, right? Especially, I would hope, especially when we're talking about victims like this. But as you'll see, for some reason, that was not the case in this instance. So let's go. First factoid from Judge. Epstein, in a bad way, abused more than 30 minor girls in between 1997 and 2007. And he used the SEX word there. In his Palm Beach mansion elsewhere in the United States. So this is why the feds got involved, right? Because there was evidence that this didn't just happen in his Palm Beach estate in the state of Florida. This happened elsewhere in the United States and overseas, right? So we can kind of assume now that that was probably his island, right? But I mean, from what I've been hearing, I think this was going on all over the world, and especially in Eastern Europe. I saw a whole segment just about his operations in Eastern Europe the other day, and I think, real quick digression with the Charlie Kirk TPUSA thing, right? With the Romania Angels, the segment I saw the other day with experts on a podcast, basically, I mean, they didn't tie it to TPUSA, right? But they tied Epstein's operations to getting these underage girls very heavily to Eastern Europe, all right? Which would be congruent with what allegedly Erica Kirk had going on over there with Romania Angels. Okay, so this connection between the TPUSA Erica Kirk, well, specifically Erica Kirk, and the whole Epstein thing seems to be playing out more and more as we look through these files and experts start chiming in. Okay. Next, and again, these are all factual findings from a judge, right? So as I'm saying these, think about some of the statements that Pam Bondi, Kash Patel have made, okay, under oath in front of Congress, right? Please, because again, with a judge making these findings on the record, based upon evidence submitted in a litigated case, you can pretty much take them to the bank. Now, that's not to say that they're airtight, bulletproof 100%, okay? But in order to, really call them into question, you would have needed to appeal. And normally on appeal, whenever there's a factual question, it's a clearly erroneous standard. So again, it's very rare that appellate court's going to say, yeah, that trial judge that was there to receive all the evidence, to see the witnesses, all this thing, and had a real feel for what it was. And that's why they're very hesitant to overturn that, right? Because appellate courts aren't there to see these things go down live in front of them. So they're very deferential to the trial court's decision on which facts are true and which facts are not. So again, carries a lot of weight. He goes on, because Epstein and his co-conspirators, okay, so the judge, again, a federal judge, because Epstein and his co-conspirators knowingly traveled in interstate and international commerce to sexually abuse victims, they violated state and federal law. In addition to his own assault victims, Epstein directed other persons to abuse the girls sexually. Okay. I'm going to read it again, but I'm not going to read the last word. Epstein directed other persons to abuse girls. Okay. So again, just keep thinking about what Kash Patel said in front of Congress under oath. Okay. Keep that in mind. Next, Epstein worked in concert with others to obtain minors, not only for his own sexual gratification, but for that same gratification for others. Okay, so here we go. In the first 3 lines of this opinion, a federal court has pretty firmly established that the facts show that Epstein most definitely was trafficking minors to other individuals, co-conspirators, right? And so here we go. Now we have Kash Patel and Pam Bondi, these other people testifying in front of Congress that they're, and I think, and let's just focus on Kash Patel because I specifically remember his more clearly. And I think they were probably the most heinous, but he said that there is no credible evidence. I believe he said credible evidence to suggest that Jeffrey Epstein trafficked minor girls to anyone other than himself. Okay. And, in my opinion, the effect of this court's factual findings of co-conspirators is it eliminates any doubt. I mean, any doubt that Patel and all the others who testified contrary in front of Congress under oath, okay, testified under oath that there was no evidence of this, right? They're guilty of perjury. Simple as that. They are guilty of perjury. And not only that, the dumbest form of perjury, right? Because it's not like I had to go and conduct an investigation to figure out whether there was some credible, accusations or of co-conspirators being involved. No, literally the federal judge had already done the work for Kash Patel in 2019. Okay. He did all legwork, man, made it real easy for him. Yeah. All Kash Patel had to do at that time, he could have just deferred and said, I think it was Senator Kennedy asking him. He said, Senator Kennedy, to my knowledge, in 2019, judge, in Southern District of Florida, did make findings that indeed that Epstein had trafficked women to conspirators. It's that simple. I mean, he really, in actuality, he should have just told him, yes, there's a bunch of credible evidence in there. But if he wanted to deflect a bit, but still not perjure himself, he certainly could have made a statement to that effect, I do believe. So anyways, I wanted to point that out. One thing I want to say is that I was watching a podcast yesterday, which played a clip of Senator Dick Durbin. Was it Senator Dick Durbin, I believe? Anyways, during the hearing, right, with Pam Bondi, and he made a comment after one of, she was being really sharp with those senators. Not a good idea, being real sharp with them. But after she was done, Dick Durbin said something to the effect that, we're gonna make sure that you answer for this. And I was hearing another attorney on a podcast the other day also said that he thinks that Pam Bondi might get disbarred for her testimony there, and really just a lot of her actions as the Attorney General. So, neither here nor there. I really never truly wish bad on people per se, but I will say that I do wish accountability on people, especially in this instance. Okay. Next fact. The FBI originally opened its investigation at the behest of state authorities in Florida because they discovered Epstein had used interstate commerce to induce girls ages 14 to 17 to engage in illegal sexual activities. Okay. Next fact. The FBI determined that the two girls suing the Department of Justice had been victims of Epstein while minors. Okay. And we're talking about the two victims that filed this, violating the rights under the Victims Act. Between January 2007 and September 2007, the U.S. Attorney's Office for the Southern District of Florida engaged in discussion with Epstein's attorneys regarding the non-prosecution agreement on federal charges. Okay, so this is going to be what most of our conversation is today, is this back and forth between Epstein's attorneys, he had multiple of them, and the DOJ, okay, about this non-prosecution agreement. Okay. So they go on to say, the FBI did send notice to victims, right? So under this act, pursuing the act, they did send, so they're obligated to make certain notification letters. Okay. So but as we'll see, they did make some, but were they truthful and accurate? Not really. So we'll keep on going. So the FBI sent notice to victims in March of 2007 about their rights under the Crime Victim Rights Act. And by May 2007, they had drafted a 53-page indictment of federal against Epstein. So again, they did not file this indictment. They did draft a 53-page indictment. Okay. And before this indictment was done, they had already provided notice to the victims that they were investigating the matter, et cetera, et cetera. Okay. So they did, I mean, in the sense that they did notify them that they're investigating, sure. Okay. But as we'll see, whether that was completely truthful and upfront is a whole different story. I'll keep going. On June 7th, 2007, the FBI sent this formal letter. Oh, I take that back. This is another. So there was the first, just so we get the timeline correct. Okay. The first victim notification, March 2007, the draft indictment, 53 pages, 53-page indictment, was May 2007. And so then they send another victim notification letter on June 7th, 2007. And this letter stated that the victims had the reasonable right to confer with an attorney for the United States in the case and to be reasonably heard in a public proceeding in the district court involving a plea. At this time, your case is under investigation. Okay. Now, with the 53-page indictment, that's a pretty dense indictment. Okay. So as many of you are probably aware, an indictment really just tracks the elements of the crime. It doesn't go into really extreme detail necessarily about the crime per se, but it really just cites the elements and makes sort of, in my opinion, kind of conclusory statements about those. Generally not super, super long documents. A 53-page indictment is a thick indictment. That is a book in terms of, indictments. And it just makes me think, it's like there's over 30 victims. Okay, over 30 victims with a 53-page indictment, yet he was entitled to a non-prosecution agreement? When the state is only giving him a slap on the wrist, like, what world are we living in? What world are we living in? Like, if you didn't have proof enough yet that we are living in a 2 or multiple tier justice system, here you go. Here you go. Because I can tell you right now, looking in the past, I would love for anyone to find me another instance where there was a 53-page indictment with 30 plus victims of this type of illegal behavior, where a non-prosecution agreement was entered into. I'd love for you to find it. To me, when I read that, it's off the map. That is off the map. Okay. And so, as heinous and terrible as how they're doing it today, the DOJ handling this matter, again, this is their lineage. Their lineage has been since at least 2007 in regards to Epstein, due at all cost. At all cost. Because let me tell you, did these attorneys put their professional and personal credibility and potentially their law license on the line to do this? Yes. Okay. And we'll talk at the end a little bit about, how is that? Because let me say this, and I meant to say this to the first, but I want to say it a little bit before we go, is that I do have, and I think we should all keep in mind, okay, who Epstein was, who he was probably most likely working for. I would say probably multiple intelligence agencies, but there's one in particular I think we can think of that has a propensity towards violence, and not only violence, public violence in a very public way. Okay. And so I always have to remember when I'm reading through these, in all honesty, ladies and gentlemen, these prosecutors could have been acting out of duress. Okay. And I'm not going to go into the nitty-gritty details of what that might have meant, but I think you can connect the dots. In a way, I want to believe that they were under duress. I want to believe that they were under duress. I would hate to think that anyone with a scintilla of moral compass in this world did this willingly. Okay. And then you can say, well, Greg, they could, if they didn't want to do this, because a lot of times we think, well, they probably did it to get promoted. They just wanted to satisfy the upper echelon, get promoted. Well, that's true enough. They could, but we can also make the decision to walk away. But there could be instances where walking away isn't a viable option. Okay. So I just wanted to paint that spectrum here for everybody, because I don't want to unfairly characterize these attorneys who are involved in it per se yet, because of the people who we were very well probably dealing with, and who they were very well probably dealing with to some degree at the time. Okay. So, and that's just to be fair. Because as an attorney and as a human being, what I'm looking at and what we're going to be talking about today, next day, is so heinous that I would just want to believe that someone was under an extreme state of duress and feared for them and their family to be engaging in this type of conduct as an attorney, as a human being. Absolutely. Between September 10, 2007, by September 10th, 2007, multiple drafts of the proposed non-prosecution agreement had been exchanged between Epstein's attorneys and the Department of Justice. Okay. So, and this is normal, right? So, well, I'll say it back. It's not normal to get a non-prosecution agreement with a 50-page indictment and 30 victims, but it is pretty normal for attorneys, defense, and prosecution to go back and forth trying to resolve a case, whether it be a plea bargain or some other type of agreement, right? So just wanted to point that out. Like, them going back and forth trying to resolve it's not abnormal. Trying to resolve it with a non-prosecution agreement in this instance is absolutely abnormal. Let's see. And let me say this. Now, there could be an instance where maybe the state was seeking life in prison or something like that, right? Where the state their laws were more favorable and they had it better teed up. Maybe their jury pool would have been better, right? These are considerations. So there could be considerations where something that severe was deferred to a state prosecution. But in this instance, I can tell you that it was not deferred to the state prosecution because they were handling it appropriately, meaning that the punishment that Jeffrey Epstein was set to receive was in any way commensurate, okay, to what was done. Okay. I'll continue. On September 12th, 2007, while attempting to create alternative charges against Epstein, right? So again, as we'll see today, they're going back and forth trying to finagle this in any possible way, going to pretty extreme lengths in terms of, I take it, the amount of effort and, grit being put into this case by the DOJ, extreme efforts to try to make sure that Jeffrey Epstein, gets the best deal possible. So anyways, yeah. So while attempting to create these alternative charges for Epstein, the Department of Justice office expressed concern about the effect of taking the position that Mr. Epstein's house. Okay. So here's what had happened. Jeffrey Epstein's lawyers apparently had asked the Department of Justice, and the reason why I think this is I think that at one time the state was probably seeking potentially harsher charges against Epstein than what they were willing to agree to. And so I think what we're about to read is an attempt by Epstein's attorneys to get the federal government to declare Epstein's house some type of special maritime exclusive jurisdiction to take it away from the state court. And the reason why I think that was because the state might not have been at that time offering them something sweetheart that they were willing to accept. And so here we're seeing again a back and forth with the DOJ at the very least entertaining the idea of trying to do that to accommodate him. Yeah, but anyway, so, taking the position that Mr. Epstein's house is in the special maritime and territorial jurisdiction of the U.S. because the government had no evidence of any assaults occurring on his plane or offshore residence. Again, I think that this was an attempt at the time to try to remove jurisdiction from the state because at that time it wasn't looking good for him from the state. Next, on the 13th, the DOJ attorney sent an email to Epstein's attorneys stating that they had been long sitting. Okay, this is pretty heinous here too. Okay, it's pretty heinous here too. The attorneys for the DOJ, and I haven't even gone to look at Title 18, but apparently the attorneys for the Department of Justice sent an email to Epstein's attorneys stating that they had spent quality time with Title 18. Again, I don't specifically know what that was, but why were they doing it? In order to try to find misdemeanors to charge Jeffrey Epstein with. Let me tell you that again. The Department of Justice attorneys said to Jeffrey Epstein's attorneys that they were spending quality time under a specific law so that way they could try to identify misdemeanors as opposed to felonies to charge Jeffrey Epstein with. I mean, you can't make it up. But it's one of those things that's like, okay, you're going to spend quality time with the law in order to try and bring this PDF files actions into a misdemeanor as a Department of Justice attorney. These people had to have been under major duress. Like they had to have been under major duress because they didn't spend quality time with their kids. They didn't spend quality time with their family. They didn't spend quality time at church or with Jesus or with God. They spent quality time with Title 18 of the United States Code to try to help fit a major felony pedophile a crime into a misdemeanor, trying to fit a round peg in a square hole, more or less. So, I don't know what they call quality time, but that's not quite the quality time I ever envisioned spending, just me. So, and by all means, had they spent quality time with God, with Jesus, we might not be here today. We might not be here. Jeffrey Epstein might have been placed where he deserved to be from day one. And all these other victims and all this other drama and death and destruction and tearing apart of this country might not have occurred. It might not have occurred, might not have occurred. But here we are. Here we are together. All right. Sorry, I meant to say when I started this that I was, I know it's maddening, Susan. I know. Yeah. And I apologize. I should have said before this, usually I'm pretty calm and collected. I'm going to express a little bit today. As a matter of fact, I put a few points in my outline to express because it's therapeutic for me. So thank y'all for listening. And I'll tell y'all at the end of this why I really, really resonate with these victims, why I'm in alignment and have empathy with them, because I've been in a very similar situation. So let me read. Okay, so the judge next quotes from an email. Okay, so this is an email from the DOJ attorneys to Epstein's attorneys. Okay, here's what it says. I have gotten some negative reaction. Okay, hold on. Sorry. Let me back up just one second. The Title 18 thing, right, was to try to find a misdemeanor, in which we already know what that was. They're doing everything in their power to try to avoid, and they admit it later, as we'll read today. They're doing everything in their power to try to avoid Jeffrey Epstein having to spend one day in jail, literally one day in jail. So on September 14th, right? So we're kind of moving through September because this is when the non-prosecution ends up getting signed. So judge spends a lot of time in this time. On September 14th, having spoken on the telephone with the DOJ lawyer, his attorneys send a proposed plea agreement to the DOJ where he would plead guilty to one charge of assaulting one of his co-conspirators. Okay, so he's got like 30 plus victims, and his attorney says, "Nah, let's not do that." But one of these co-conspirators, though, that was help, and I think what they're referring to is one of the either minor or younger women who had been out there helping him, like procure girls. I think what they were proposing was like, "Hey, he'll plead guilty to assaulting her. How about that?" And not these other victims. And here's what they got in response from the DOJ. I have gotten some negative reaction to the assault charge with a co-conspirator as the victim. I mean, I can't believe that they asked. I mean, really, they really went to, I mean, so that tells you right there what type of environment this even was in the DOJ. Something as ludicrous as like suggesting that he plead to a charge like that is something that this person felt was okay to like go and bring up to other people in the office. Like I would never, no. It goes on. Since she is considered one of the main perpetrators. So it's like, yeah, so since she's one of the main perpetrators, why don't we just plead guilty to him assaulting her? And it's not funny. It's really not. I'm sorry, y'all. Sorry. And so since she is considered one of the main perpetrators of the offense that we plan to charge in the indictment, and here goes the DOJ pandering. Can you talk to Mr. Epstein about a young woman named Jane Doe? Which obviously this was excised. We have hearsay evidence that she traveled on Mr. Epstein's plane when she was under 18 in and around the 2000 or 2001 timeframe. Look, they got 30 plus victims who can give direct testimony. Here they are asking about trying to rein in some unknown through hearsay to charge him with. Man. Oh, Lizard is around. He's been in the comments. Sorry, Lizard has been around. He's been in the comments. I hope he's okay. Well, I'll just talk to that later. But afterwards, the DOJ lawyer sends an email offering that Epstein plead guilty to obstruction of justice for pressuring one of his co-conspirators not to turn over evidence or complying with a previously served grand jury subpoena. So again, y'all, I mean, here we see, I mean, the fact that these conversations, the fact that the DOJ is entertaining these things is really beyond me. This is beyond, and it is a horrible problem with our system, Susan. Yeah. And they go on. Oh, here we go. This is, when Barron tells people to like sit square in your chair and like buckle in, y'all probably, I'm going to do it because this next one is pretty heinous. Next, the DOJ lawyer says, on an avoid the press note. Okay, so this is how they're saying the email to Epstein's attorney. Hey, on an avoid the press note, I believe that Mr. Epstein's plane was in Miami on the day of the co-conspirators' telephone call. If he was in Miami-Dade County at the time, then I can file the charge in the district court in Miami, which will hopefully cut the press coverage significantly. They also discussed having Epstein plead guilty to a second charge of assaulting a different co-conspirator. Okay, so again, the whole move to obfuscate, to keep this from the press, to keep this from the public, and unfortunately to even keep it from the victims is something that was designed, okay, even though we're seeing it really play out today in 2026, this was an ultimate design, and this was imprinted into the modus operandi with Jeffrey Epstein as it relates to DOJ back in 2007, okay? This concerted effort, even to the point of changing venues, okay, even to the point of changing venues in order to avoid as much press and publicity as possible, right? Because why would we want that? It could be hard. Look, y'all, press could have been very harmful to Jeffrey Epstein, y'all. His co-conspirators, it might have hurt them too. I mean, come on now. If a lot of press, if we had known about this back then, they might have gone to prison. Okay. So y'all don't be upset. They could have gone to prison and people might have been very upset. It might have even uncovered the whole cabal back in 2007 had we been more aware of this. But what's the most sickening thing to me is when I think about, again, all the victims, okay, from 2007 to 2019, okay, the fact that Jeffrey Epstein didn't go to prison, and the fact that this was intentionally obfuscated from the public and from the media. I mean, I venture to say that some of those victims, some of that, all that could have been prevented. Just a thought, maybe, I don't know. But, in avoid the press note, while they were trying to avoid the press, they should have been trying to avoid the victimization of all the underage minority victims that surely followed all this, because, those efforts put towards actually doing justice instead of trying to hide might have made a big difference in our world today. I venture to say it absolutely would have. With as deeply connected and as much problems and trouble that Jeffrey Epstein, his network, and his activities have created for us in this day and time, had these people done the right thing, and just real simple, just done the right thing, just imagine what life would be like today for us. Like a whole paradigm shift, ladies and gentlemen. Like it could have really been like a whole paradigm shift could have occurred had these people stepped up and done their next right thing. So with that being said, I mean, I hope that somebody either had a pew pew aimed at their head or serious threats going on, because anything short of that is makes this behavior inexcusable in my eyes. And again, I'm no saint, I'm no perfect person by any stretch of the imagination, but I for sure have been very solid my whole entire life on the defense of children and minors, especially in these respects. So I can say that. Lest I digress. Let's see. Okay, so we just covered that they were, very early on when this thing was getting signed, seeking to avoid public disclosure of the press to the point of even potentially moving venues. Okay, you can't make it up. Let's see. Okay, here we go. Now here's what the DOJ lawyer says next. They state that the office didn't like the factual basis of the proposed charges, as they were not investigating Epstein for abusing his girlfriend. They also stated that Andy, and I think this Andy person is actually like the one U.S. attorney that we are aware of that was working on this, the one that I think has gotten pinned with being responsible for all this. I recommend that some of the timing issues be addressed. Oh, okay. This right here is where, and you thought it was bad already with the intentional obfuscation and the potential of violating some of our professional and ethical duties as an attorneys. Here you go. Here's what the DOJ lawyer stated to Epstein's attorneys. I recommend that some of the timing issues be addressed only in the state agreement, talking about the state plea agreement, so that it isn't obvious to the judge, the state judge, that we are trying to create federal jurisdiction for prison purposes. And they didn't, and it's not prison purposes like you would imagine, it's to avoid prison purposes. I will include our standard language regarding resolving all criminal liability, resolving all criminal liability, and I will mention co-conspirators. Hey, Cash Patel, you need to listen to this. And I will mention co-conspirators, but I would prefer not to highlight for the judge all of the other crimes and all of the other persons we could charge. So they intentionally showed up to state court with a plea agreement that was specifically tailored not to alert the state court judge to the severity, to the true nature and depth of this whole thing. And why do they do that? Because the judge in the state court can say, no, I will not approve that plea agreement. So if judge in the state court had been apprised of everything they feared that their plea agreement wouldn't go through. Because any rational human being with a half of a moral compass, with 1/160th of a moral compass were to see this, wouldn't have signed that plea agreement. Absolutely not. Absolutely not. I mean, I say that, but there's a pretty large concentration of a certain group of people in Florida that might have been on the bench in the state court that might have, but here we have it. They were intentionally drafting this plea agreement in a way to obfuscate for the state court all the most horrible things and the true nature and breadth of this, in order to make sure that Jeffrey Epstein could continue to live his life pretty much the same the way he was before, minus a few minor inconveniences. And that's what he got. That's what Jeffrey Epstein got. And we all know what we got. We all know what we got. A lot of respect for the American taxpayer and the public and these victims with the Department of Justice. A lot of respect. I'm glad they're thinking about us. Glad they're thinking about the victims. Great people. So let's go on. In the same email chain, the Department of Justice lawyer asked his attorney, as Epstein's attorney, to set up a time to meet off campus. Okay, so like the DOJ attorney wants to meet not in the U.S. attorney's office, which is usually at the district courthouse. Definitely not there, but they wanted to meet somewhere else. I wonder why that is. On September 16, 2007, Epstein's attorney provided a proposed non-prosecution agreement to the DOJ that extended immunity. Okay, so this is Epstein's attorney sending a proposed non-prosecution agreement to the DOJ, okay, attempting to extend immunity from federal prosecution, not only Epstein, okay, but also certain co-conspirators. So again, Cash Patel. Cash. This co-conspirator thing's been known by the DOJ for quite a long time, man. I just don't understand, and please correct me if I'm wrong, I just don't understand how what we're reading today in a federal court opinion in any way doesn't implicate co-conspirators. And to the point where, your statements in front of Congress were not perjured. We're not perjured. The DOJ sends an email to his attorney saying, please send a document to my, okay, here we go again. Please, telling Jeffrey Epstein's attorney, please send me a document, not to my work email address. Please don't send it to my email address that's going to be on these government servers. Please don't do that. Send it to my home email address. So that way I can be ready for tomorrow's meeting, for our discussions tomorrow. His attorney then responded asking, do you have another obstruction proffer I can review that you have drafted? Also, if we go that route, would you intend to make the deferred prosecution agreement public? Okay, here we go. So he's asking, DOJ, if we agree to certain things, would you agree not to make this public? Okay, here goes the response. In response, the DOJ says, a non-prosecution agreement would not be made public or filed with the court, but it would remain part of our case file. And now, in all fairness, that might be normal procedure. These non-prosecution agreements, I do see why they wouldn't be filed with the court per se, especially if no indictment's been filed, obviously. But, specifically promising that they would not release that to the public, is that intentional obfuscation? Is it? Let's see what I was going to say here. So they say, so we would, it probably, so here next what they say is it probably, talking about this non-prosecution agreement, it probably would be a FOIA request, meaning that they would have to disclose this if a FOIA request came, but it is not something that we would distribute without compulsory process, meaning that if we were to send a FOIA request to the DOJ, I think what they're saying here is that they would not immediately disclose it then either, that we would have to go to court and have, a judge order them to disclose this non-prosecution agreement. Just because, and this is to Kash Patel, again, just because the DOJ doesn't want to see specifics about pursuing other charges against these other co-conspirators does not mean that legitimate evidence of trafficking by Jeffrey Epstein's to co-conspirators does not exist. Basically, the way I take it is that Kash is wanting to equate the Department of Justice. So Kash Patel is trying to equate the Department of Justice's hell-bound intent to protect Jeffrey Epstein and his co-conspirators and elite buddies. He's trying to equate that desire and a lot of action in that direction to we don't have evidence of any legitimate evidence that there was anybody else involved. I mean, that's the way I take it. The only way I can make sense of it is that his desire to protect these people is so great that he, under oath, equates that with there's just no evidence of it. There just can't be. I desire so bad to make sure that these people remain safe and protected that there's just not any evidence of it. No credible evidence. Lest I digress. So on September 21st, 2007, so again, this September is when they're starting to finalize this non-prosecution agreement. Okay, so on September 21st, the Palm Beach County State Attorney wrote the line prosecutor. So when they say line prosecutor, they're talking about, and then they don't name this person, and I kind of understand why. The prosecutor at the DOJ wrote about the proposed agreement and added, glad we could get this worked out for reasons I won't put in writing. Yeah, so the state prosecutor writes to the DOJ attorney saying, hey, I'm so glad we were able to work this out, but I'm not going to say in an email why that is. And then goes next to say, after this is resolved, I would love to buy you a cup of Starbucks and have a conversation. So, yeah, working hard to protect PDF files and their co-conspirators, man, it is worth a cup of coffee at Starbucks. Worth a cup of coffee at Starbucks. Man. I guess you sell your soul to the devil, right? I guess you sell your soul to the devil is worth a cup of Starbucks coffee. Yeah, selling your soul to the devil to protect PDF files is worth a piping hot cup of Starbucks coffee. What happened to becoming a rock and roll star, huh? What the hell happened to becoming a rock and roll star for selling your soul to the devil? What happened? Now it's only worth a cup of Starbucks? Man. But apparently that's where we're at, or that's where they were at in 2007. I mean, I wonder if the price has increased any. I think there's a few people in the public eye right now that we might be able to ask that question to that might have some pretty good answers for us, huh? Possibly. Possibly. Man, I know, y'all. And to be quite honest, I was reading and and it'll make more sense at the end of this when I say why I'm really empathizing, but like it made me so sick, y'all, and just unsettled spiritually in bed last night, really reading through this, that I had to just let it go and say, look, I'll just cover this much, the live stream tomorrow. I can digest this tonight and I can process it tomorrow and create an outline. Because that's how this has affected me too. Terrible. And also too, just so y'all understand, is I also have this aspect of being a prior drug addict and being on the wrong end of a prosecution and seeing people attacked by prosecutors all my life and being told how big of a POS I am and stuff, what would you I don't want to say irony, but the hypocritical reflection point there's too much for me at times to bear. Next they say, so after the Starbucks cup of coffee, the prosecutor then emailed Epstein's counsel and stated, I think that the attach addresses the concerns about having an unlimited number of claimed victims. Okay, so what does this tell me? It tells me at the time they had a really good idea that these 30-something victims was not the whole cornucopia, ladies and gentlemen. They had a pretty good idea that this thing was much bigger than what was in their file docket at the time. And so obviously what was going through their mind is that when we do this non-prosecution agreement, should we account for the fact that there very well might be, like you say, an unlimited number of victims? I mean, it's not funny. It's not funny. It's certainly not funny. I think that the attached addresses the concern about having an unlimited number of claimed victims without me trying to bind girls who I do not represent. So, hey, that was kind of ethical. At least Epstein's attorney was thinking for these other victims in the future that he didn't want to enter into an agreement that might affect their rights negatively. Like, man, did you come to find out he's like one of the most moral people there? Incredible. It's just incredible. Just incredible. Okay. And we're almost to the end of this, and then we'll just do some general discussion. I'll do the comments. On September 23rd, 2007, the U.S. Attorney's Office sent an email to the state prosecutor saying, it is factually accurate that the list we are going to give you are persons we have identified as victims. If we did not think they were victims, they would have no right to bring suit. On September 24, 2007, the DOJ prosecutor email to a prospective representative for Epstein's victims. And so part of this, and we'll get a little bit more into mine, but part of this is also kind of a civil thing. Part of the non-prosecution agreement set up, and again, I need to look more at it, but it pretty much set up a civil thing where these girls could assert civil claims. And so part of the DOJ and state prosecutor were trying to find more or less an amicus or ad litem attorney, for lack of a better descriptor, to help represent these victims, right? So that's really what they're talking about here. But hey, which lawyer they pick matters, as we'll see, because depending on which lawyer they pick, it might get out to the public more than other lawyers. So that's the primary consideration, as we'll see. If we did not think they were victims, they would have no right to bring suit. Okay, he goes, the email confirmed the girls' status as victims, stating, please keep this confidential because these are minor victims. This is a preliminary list. Later in September of 2007, that same prosecutor sent an email to the state prosecutor. The DOJ prosecutor sent an email to the state prosecutor stating, I have compiled a list of 34 confirmed minors. As correspondence continued on September 24th, and the NPA was being executed, the state prosecutor sent an email back to the DOJ prosecutor stating, "Please do whatever you can to keep this from becoming public." So again, that's the prosecutors, twin prosecutors. Everything you can to keep this from going public. You know? Yeah. I mean, all I can think right now is just a quick moment of silence for these victims. And as we know now, there's probably quite a few that never made it. Oh, we know that there actually are some that didn't make, but there's probably unknowns that didn't make it, and my heart goes out to them. So I guess it's a good time to segue into me. As I've said, I was a drug addict for 17 years, and my mom died from a sudden heart attack when I was in law school in 2010, and really sent me for a loop. And so by 2014, I was so bad I wasn't even practicing law. I was living on the streets. I was homeless, out there in the middle of it, and I ended up getting kidnapped over a $17 drug debt at gunpoint, and had my skull essentially crushed in with a fireplace poker, and barely escaped my life. But the way that I can sympathize with these victims is because in the jurisdiction that I was in, the people my attackers were in with law enforcement, right? And I had to go seek medical treatment at a hospital, things of this nature. And so I've been in that situation of being a victim, and the only people, authority other than myself to try to protect me are not looking good. And it's an extremely helpless feeling. It's a very intense fear. And, in my case, though, I was able, this was a locality, like a municipality conflict, right? I could go 20 miles and presumably be in safe territory. It's not like that when the DOJ is sold out to your attackers, for lack of a better descriptor. So that's why I really get emotional in this, because I've been there. And I could just imagine, to the extent that the allegations against Trump are true, could you imagine being a victim like that? Like seeing this person become president of the United States, like chief law enforcement officer of the United States? Like, man, I couldn't imagine. I could not imagine. Okay. I had a few other things though that I wanted to talk about. So yeah, I'm very disgusted. I mean, I think I've expressed that. Very disgusted, y'all, on the emails. I hope that if there's one thing that we learned from today, it's that what we're seeing today is very systemic. This is a lineage. It's okay. Here's another good data point that's obvious. This transcends political parties, right? Because true, in 2007, that would have been Bush. Okay. And but I think as we're seeing though, I think it's fair to say that, the Department of Justice could have potentially proceeded and done something, because let's be honest, right? I mean, they were probably very well aware that Epstein kept doing what he was doing. He didn't go to prison, so they could have gone and got the dude, right? Could have gone and got the dude. I'm going to look into this non-prosecution agreement and just see exactly how much, it did absolve him from criminal liability, but it definitely could not have, as far as I'm aware, absolved him of future criminal liability, which we know now there was a lot of that, unfortunately. Let's see. Yeah. Oh, one thing I want to say, and I think I said this yesterday, but I just want to reiterate, is I heard Ian and Tucker were talking about the Epstein file release, and just made a good point that, protecting the kids is hopefully one issue that can bring all of us together. Hopefully that can be one issue that we can all put everything aside to come together to say we agree on this. And, I never thought we'd come to the day where I'd say the most important issue in this country, hands down, is that we need to figure out how we're going to protect the children. We need to figure it out. And this is a bipartisan issue, ladies and gentlemen. It is a bipartisan issue. Let's see. Oh, so and I also was listening to a thing with Thomas Massey, I think yesterday, and he related that the victims are very upset, and I don't blame them. I mean, not only are they upset, I would imagine they're very, very fearful as well. Especially, man, with all of this, and still nothing has been done, and still nothing's been done. Could you imagine the hopeless or helpless feeling that would bring upon you? Incredible. Now, while Massey thinks that this latest release and all of the illegal redactions, that's what they were, illegal redactions and non-redactions that were made, he thinks it was incompetence. I don't think so. I think, especially when we're looking at this from 2007, I think this is a clear pattern of behavior, a clear pedigree, a clear lineage of behavior that this DOJ has inherited. He's like, surely some lawyer out of the hundreds or whatever that they had reviewing these files would speak up if they felt that something unethical or evidence was being destroyed or things of this nature. I would hope to think that they have ethics that would dictate that. But again, we can't write off that these people aren't being threatened. I'm not going to write it off. I mean, based upon what I'm seeing from this administration, the idea that there might be some underhanded threats going down for people who might want to get smart and go out here and tell us really what's going on. I mean, I'm not going to say for sure 100, but it's in the possibilities for me right now within that. So yeah, my inclination is not to believe that this was just clear incompetence. I think it was very, very targeted, very purposeful. And, I think it was Ian also that said that, when you look at these things, you can tell that, oh no, it's Massey. Massey said that you can tell that a lot of the other redactions, like a lot of the ones that we're looking at and don't really make sense, are done to obfuscate us understanding or getting an idea of what the actual circumstances were in some of these more heinous situations that are in the files. Yeah, so Massey stated, so I have not had a chance to read the drafted indictment. I'm assuming it's in the Epstein release. I'm going to go look at this 53-page indictment. I'm very curious now what was in there. Because again, that never got filed. That was something that was done at the very start, I'm sure, to normally something like that would have been done to try to scare Epstein's attorneys and Epstein into like copying a plea. So I'm sure that was probably done as a matter of course, so I'm anxious to go look at it, but obviously for this non-prosecution agreement, it was, that wasn't made a part of it. Right. But Massey did say that indictment's pretty heinous. Massey thought it was kind of odd that, the act that he passed, that he got pushed through, requires that Pam Bondi be doing all the releasing and handling of all this, but yet she's passed the buck to Todd Blanche. I don't really know what that's about. Although I think I've said, Kana and Massey are intending to go to the actual DOJ and look at these the unredacted documents themselves. So yeah, we'll see how that pans out. So yeah, all right. So let me look at some of the comments. I had some more stuff written down, but it's Sunday, y'all. It's about I got to use a little boys' room in a minute, but we'll get through this real quick. Go through the comments. Thank you everybody for being here. Thank y'all. I just very grateful, honored, blessed for you to be here. And before I get into the comments, any love, liking, comment, sharing, definitely subscribing, be very helpful. I'm going to keep coming with this level of content on, I say a daily, but reasonably consistent basis. And if you like it, show us some love, be very much appreciated. I am kind of just doing this all alone out here. And we're just going to see where it goes. Thank y'all. So yeah, let's see. Hey, Raining, very nice to see you too. Thank you for showing up and being part of it, Lisette. Thank you. I'm doing well. Oh, you're talking to Susan. Let's see. And I will say, I have a really good comment section. Like, I don't see any infighting going on here. I see love in one another, and some good conversation, some actually productive conversation going on. So I told my wife last night. I said, we're coming up on 900 subscribers, but 900 quality subscribers, man, quality subscribers. And then God is good. I heard something about E having a home in Switzerland yesterday. I mean, hey, Susan, based upon what we know, that's, yeah, likely. Us little people have no chance against the government. Well, in a sense, you could think that, but look, um, and I'll go ahead and say this. I'm going to do another probably episode. We'll do a live stream on it, but I'll just let you know my thoughts. Is I'm very concerned about the midterms. Um, I'm concerned about whether we'll have a full and fair midterms, to be quite honest with you, for a number of different reasons. But the reason why, and that's not to alarm y'all, I will clarify. There's some nuance there, so I'll definitely clarify later. But, the ballot box, y'all, that's where we have the chance. I mean, I think we kind of, the good kind of the light that we see out of all this darkness is that it at least illuminates for us, I think, what the underlying issues are. Uh, the underlying problem of certain interest groups, demographics that have absolute control over, our government in most all respects. If let's just agree that if we focus on eliminating that issue, I think we're going to be making good headway, and I think that we can get back somewhere within the universe of a government for the people, by the people. Okay, so yeah, I hate that we feel that way. It sucks, man. It really sucks, and we feel like we have little people no chance against the government. I mean, I could just imagine how these victims feel. Like times two of what we feel. Um, Linda, I've been aware of pizza being a code word for a child essay for the last 10 years, but yet the powers that be are claiming they had no idea. I mean, what? Yeah. So just to be honest with y'all, I had not really gone too far in depth on the Pizzagate thing per se. Not that I ever thought that it was completely bogus. I mean, the stuff's pretty compelling, really. But I've really been now, watching some shows and looking into it, and it's like, man, I mean, that was really just a little synopsis of what was to come right through this whole Epstein debacle and file release that we're going through. Um, let's see. How can they live with themselves though, knowing the truth and dealing with the devil? Um, the only way, I mean, the people who actually committed these things, I mean, you got me on that one. You definitely got me on that one. The people who are obfuscating and supporting and covering up for it, now that's a good question. Again, I would sincerely hope that these people are under major duress. You know what I mean? Like major duress. And it would have to be major duress for me, for sure. That's the only thing I could say that would be in any way, helping them out in any way, I guess I'd say. Otherwise, I think it's just people are so self-interested. Yeah, that's really what it boils down to. So self-interested in their power, in their position, and in their money that another human being is doesn't even come on the radar as far as a consideration that might get them to come off that a little bit. Yeah, sad. Let's see. They didn't spend quality time with Jesus. They spent it trying to minimize the atrocities of a PDF file. Thank you for expressing. Yeah. Yeah, I had to this episode. I try to keep my emotions pretty well under check as much as possible, within reason, especially doing this, right? I want to come and be, as calm and collected and objective as possible. But this is just one of those things where I just it had to express. I feel better though. I really do. I feel better. Absolutely. Lizard has been around in the comments. I'm not sure why he hadn't been here the last couple live streams. Much love to him and prayers. But we exchanged some comments, and he seemed like he was doing okay. So hopefully he'll chime in here. Maybe not too long after we close down. Let's see. Sounds like the DOJ was assisting the defense attorneys. I mean, that's basically what they were doing. I mean, they were basically mollycoddling, I think that's how you say it, or, trying their best to accommodate Epstein in a way that would mean he would essentially get to continue doing exactly what he's doing. I think that he was like on an ankle bracelet in his mansion, and if some of the kind of documentaries and stuff I'm seeing are factual and correct, like he was still up to it then, while on probation with an ankle monitor in the home. Thank you, Random Doc. It is frustrating. It is frustrating. It absolutely is. It's one of those things. I think sometimes it's like, out of all the different crimes that we've defined in our society, think about it, all the different crimes, whole plethora of them. You would figure that any crime that like physically harms or mentally harms a person, in this kind of severe way would be the top priority, above all else, but I can guarantee you that in the Southern District of Florida at the time that this agreement went down, I bet you they put people in prison for 20 plus years for doing nothing but selling marijuana. You know what I mean? Nonviolent offenders doing nothing but selling marijuana. I bet you they threw the book at those. That's another thing that really gets up under my skin. I bet you they threw the absolute book at those people, and we're flipping the bill for it. And we're flipping the bill for this too. And it's not only monetary damages, right? It's not only monetary damages. It is severe emotional distress on the victims especially, but hell, the whole American public, from what I'm seeing here and what I've seen elsewhere, people expressing their feelings about it. Yeah, man. Let's see. How many of you in here voted for Trump? I did. I'm fucking. Hey, God bless y'all too. And I've said this before. I'll admit I haven't voted in a very long time, but I would have voted for Trump this last election. And I really have been hard on myself because of that over the last several months, based upon the research and things I'm seeing. Just the thought that I would have has been kind of hard. But look, y'all, these people, I'll put it to you like this. They have gone through extreme lengths to hide and obfuscate this, and they've had obviously manipulated the media and algorithms, all this stuff. And so look, in a lot of ways, we didn't stand a chance. We didn't stand a chance. But here's what I will say. Now you know. Okay, so now we know. And so next time, and again, this is not trying to tell anybody to vote. Look, I want you to transcend the left versus right paradigm. So what I'm saying does not mean go vote for a Democrat or don't go vote for a Republican. It's definitely not saying that. But I am saying that hopefully whatever voting decisions we make is done with a much higher level of awareness and commitment to researching and knowing exactly what we're doing when we're showing up there. Oh, thank you for the prayer, Ellen. Thank you very much for the prayer. I appreciate that. Oh, Bonnie, thank you. Again, I haven't been a perfect angel in my life. It's all a journey, right? But I can guarantee I've never harmed a person in this way. I've never been criminally charged. I mean, sure, when I was a kid and growing up, when I was homeless in the street, there were fist fights and stuff, but other than that, I've never physically harmed a person, right? Nor would I, unless it's something that is forced upon me, right? So yeah, I can sit here and take a little bit of a high horse on this one for sure. And I will, because to me, this is extremely basic morality. right? Extremely basic morality. Like you don't need to like open up and read the whole Bible or any other, spiritual holy book to get this type of knowledge in respect for humans. It should be innate. Now I do realize that some people are born in, or come across or raised in a certain way that puts them in that frequency, but again, I'll say this, most people who do these things go pay the price for it. So that's kind of the equalizer, right? But when you got people like this who don't, that's where the major issue comes, right? I mean, I don't like it. Don't get me wrong. I don't like it. But to the extent that people do the time for the crime, well, we've got some offset there. This right here is such a huge deficit and this isn't coming out as a clean audit on the justice system here. It's nothing bill of health, ladies and gentlemen. And I've been aware that this is one instance of injustice that is much more systemic in many different, very complicated facets and ways. But it is an issue. Okay. And so I hope that bringing this to your awareness, even just understanding how these things normally go down and what happened here, you can turn your radar on there. And next time you might become aware of a similar situation, maybe you want to see to it that these things, that they don't keep this in private and that these things are released to the public and that victims are being, handled appropriately, Let's see. Craig, is there a statute of limitations for child SA state dependent? I don't think there is. Hold on. While we're on the issue, let's look real quick. That's a very good. I don't think so. I'll just say off the top of my head, I do not think so. And I think proof of that too, or indication of that, is the fact that these people who are in these files, co-conspirators, allegedly, they're still freaking out. So I think the fact that they're freaking out means that there is no statute of limitations on something like this. All right. Okay, most don't. Most do not, especially for serious felonies. Okay, so federal, there is no statute of limitations for aggravated abuse of a child, abuse of a child, trafficking of child, CP production, so producing profane materials with children, for other child offenses under the federal. Typically, the clock typically runs until the victim turns 28 or 10 years after the offense, whichever is longer. I'll just say this. I would imagine any offense that involves the actual physical touching and doing something with a child, I don't think you can ever squirm out of that. Some of these other ones, perhaps with like publishing, CP, stuff like that, maybe so. But for the most part, no. No. Hiding a prosecution itself should be illegal. I mean, hey, that's kind of also another, that's an interesting issue that we're looking at with the, Tyler Robinson thing. Oh, thank you, Random Doc. Yeah, man. Hey, to say I'm very blessed and grateful and honored to be here talking to you today, that there's there's a lot of chances to not to happen. Absolutely. So thank y'all. Yeah. And I don't, look, to be quite honest with you, I did not look forward to sharing that, but after mulling it over, I felt that, to let y'all understand where I'm coming from and why I'm a little bit more hardcore about stuff like this and taking a little bit more of a firm stance than I do on some other things, why that is. I've come pretty far, Lisette. No, you're right. I mean, and look, it's all a journey, right? Life is a journey. I'm learning lessons every day. And, I tell people all the time, it's like, as long as you're learning and applying and at least intending and trying to do better, that's all we can do. Wake up every morning with that commitment. I haven't seen where a lot of people, especially public officials and stuff these days, are making a similar commitment, right? Let's see. Greg, I'm not an attorney, not planning on to. After many hours of research, I'm interpreting Jessica Ruth Gonzalez versus USA SCOTUS case as roadblock to municipal accountability. Leora, let me look into that. Just a second. Jessica Ruth Gonzalez v. USA. Let me look into that and I'll report back. I don't know anything off the top of my head, but thanks for bringing that to my attention. Much appreciated. I will look and we'll report back. Let's see. All right. Well, ladies and gentlemen, that's going to wrap me up for today. We're at an hour and a half. That is right along the timelines I was hoping to keep, believe it or not. So, man, thank y'all very much. Again, so let me read this. So for tomorrow, we're going to be looking at the next piece of this same document, okay, which I did drop a link, just so y'all know, if you're interested in looking at it. But so tomorrow, though, what we're going to be looking at was is more of the concerted effort to keep this hidden from the victims, okay? In all, I guess, looking at kind of the subject matter, I've really been focused on the DOJ's treatment of the victims. Today, we're really kind of focused on their treatment of Jeffrey Epstein. But tomorrow is going to be the real focus on what they did with these victims. That was, in my opinion, very heinous. And I mean, as the judge said, illegal. So we're going to be covering that. And so, yeah, that's it. I hope you all have a blessed and happy rest of your Sunday. I am very grateful and honored that y'all were here with me today. Tomorrow, I'm going to do an episode tomorrow. I just committed to it. Thank you, Random Doc. I appreciate it. I will scratch up my outline tonight. I have a bunch of legal work and stuff to take care of tomorrow morning and probably almost going into the late afternoon. So I'm going to do as much preparation as I can tonight. I might not have as dense of an outline done, but I will have highlighted kind of like I did with these, talking about what the court states. And so I'll at least have that to go through each of the highlighted sections and talk. But I will try to put as much of it together as possible. But we will do a live tomorrow. And much love, y'all. Thank y'all very much. All the like, comment, support, subscribe if you haven't. Very much appreciated. Much love, y'all. Y'all have a blessed evening.